Hi everyone. Today we are going to talk about the patentability requirements, ownership and infringement of patent rights in Malaysia. To begin with, I would like to introduce to you what is patent. Patent is a government grant to an inventor, rendering the entitled legal right for his invention. Such right conferred by the patent is in the language of the statute and of the grant itself, that whoever possesses a patent has the right to exclude others from making, using, selling, or by all means trying to imitate the patented invention. Next, what are the laws governing on the matter of patent? For information, there are two statutes dealing with this matter in Malaysia. There are the Patents Act 1983 and the Patents Regulations 1986. Both statutes are administered by an agency which is responsible for the development and management of the intellectual property system in Malaysia. It is named as Intellectual Property Corporation of Malaysia, or is better known as MYIPO. Our presentation today is going to focus on three main fields of patent, which are the patentability requirements, the ownership of the patent right, and the infringement of patent right. Moving on to the objectives of our assignment. In completing this assignment, we aim to have a further understanding on the theories and the concepts covered in our course. Besides, we aim to be able to analyze on law of patent in Malaysia.
Okay, greetings to Doctor. My name is Lim Kai Yi, metric number 264795, and I would like to explain a little bit about the patentability requirement. So, according to Section 11 of Patents Act 1983, there are three requirements of patentability, which included that, firstly, the invention must be new, secondly, it involves an inventive step, and thirdly, is industrially applicable. And I would like to explain briefly about these three requirements. So firstly, the invention must be new. So this was clearly stated that under Section 14 of Patent Act, an invention is new if it is not anticipated by prior art. And in the case of King Time International Limited and other versus PROF E and C Sendirian Berhad, a quite new case in 2018, and there is two tests for novelty. So the first one is to determine whether element of the invention in the claim is disclosed in prior art, and the second test is whether a person in ordinary skill is able to perform the invention claim based on the prior art. So the judge held that if the answer for these both tests is affirmative, so the novelty cannot establish. And next, I would like to explain a little bit about the prior art in the section. So in the section 14 clause 2, it was explained that prior art includes everything disclosed to public orally, by written, or in any other way before to the date of patent application claiming the invention, and such contents are included in the patent granted. So there are three exception situations which the disclosure shall be disregarded under Section 14 clause 3 of the same Act. So the first one is if such disclosure occurred within 1 year preceding the date of the patent application, and if such disclosure was by reason or in consequence of act committed by the applicant or his predecessor entitled. So the second one is if such disclosure occurred within 1 year, same as the just now one, and preceding the date of the patent application, and if such disclosure was by reason or in consequence of any abuse of rights of the applicant or his predecessor entitled. And the last situation is if such disclosure is by way of a pending application to register the patent in the United Kingdom Patent Office as at the date of coming into the force of this Act. So I would like to enter to the second requirement, which is involved inventive step. According to Section 15 of Patent Act, an invention shall be considered as involving an inventive step if, having regard to any matter which forms part of the prior art under paragraph A of subsection 2 of subsection 14, such inventive step would not have been obvious to a person having ordinary skill in the art. So I will explain about the word obvious and the person having ordinary skill in the explanation later on. Okay, in the case of Helen Cole versus Brabantia UK Limited, the judge held that the word obvious in the Section 3 of Patent Act 1977, which is the Patent Act of United Kingdom, is not directed to commercially obvious. The basis of the law is that the public are entitled to manufacture which has been published in the sense of making available to the public with obvious modifications. So here the obvious modification means technically or practically such manufacture would be obvious to the unimaginative skill addressee in the art. So I would like to explain a little bit about the person who's skilled in the art. In the case of McHone Medical UK Limited, Nagore versus another, so it was stated that a person who's skilled in the art is said to be a person who possesses common general knowledge of the subject matter in question and has a practical interest in the subject matter of the patent or is likely to act on the directions given in it. And lastly, Wallace, unimaginative, is reasonably intelligent and wishes to make the directions in the patent works. And in the case of Windsurfing International versus Tabor Marine, Great Britain, so the judge held that there is 4-step test to determine the requirement. So the first one is identify the inventive concept embodied in the patent in suit. And secondly, the court has to assume the mental of the normally skilled but unimaginative addressee in the art at the priority date and to impute to him what was. And thirdly, identify differences existing between the matter cited as being known or used and the alleged invention. And lastly, the court has to ask itself whether, viewed without any knowledge of the alleged invention, those differences constitute steps which would have been obvious to the skilled man or whether they require any degree of invention. So after the test, the inventive step could be determined. The requirement of inventive step could be determined. And I would like to move to the last requirement, which is industrially applicable. So according to Section 16 of Patent Act, an invention shall be considered as industrially applicable if it can be made or used in any kind of industry. And this requirement demonstrates the practical nature of patent law, which requires that the invention should be something which can be made industrially or relate to an industrial process. And according to the Manual of Patent Practice by Patent Office of UK, industry is defined as any useful and practical as distinct from intellectual or aesthetic. And it is restricted neither to tangible material nor to purely commercial or profitable activities. And in the case of NRDC's application, the High Court of Australia, they held that to meet the industrial applicability requirement, there must be something in which a new and useful effect, be it creation or alteration, may be observed. And the mentioned manual also stated that if the method of testing is applicable to improvement or control of a product, apparatus or process, it is capable to be regarded as industrial application. Therefore, the authorities shall indicate the purpose of the test. So, for instance, the use of animal for test purpose in the industry, in particular, the monitoring water or air pollution. So, it could be patentable. So that's all from me. Okay, thank you.
Hi, my name is Lim Jing Jae, and my entry number is 263576. So in this video, I'm going to discuss about the ownership of the patent right. So why is it so important to determine the ownership of the patent right? This is because it's actually determine who has the right to control the use of the patent, to work the patent, to deal with the patent, for example, to sell, to transfer, or to assign another person to have the patent, and to sue for the infringement. So in this video, I'm going to discuss about the concept of the patentee and the inventor, and then the general rule of the ownership. And then there is actually 3 exceptions to the general rule. I'm going to discuss one by one, whether the inventor is always be the patentee, or there's another way around as the exception apply. So now you could see the patentee and the inventor is usually discussed together because they are so close linked to each other. But actually there are 2 distinct concepts. Inventor is the person who produced the invention, but the patentee, according to Section 3 of Patent Act, is actually the person who registered for the invention. So if there are actually more than one person, 2 or more person to make the invention, they are recognized as a joint owner to the patent. So the joint inventor could make an application jointly by all the joint owners according to Section 26 of Patent Act. So that the joint inventor could, through this Section 26, do make an application jointly to have the joint ownership to the patent, and then they become the joint patentee. So according to this case, Brunei, Poland, Netherlands, PV, and others, and MT Agro-Industrial Engineering, FARHAH and others, the joint owner have the equal right to the patent, unless they agree among themselves as to the extent of their co-ownership. So generally they will have the equal right, unless they agree to among themselves do not have the equal right. For example, to have certain limitation on other person's side, they could make this, but generally they will still have the equal right to the patent if they are the joint owner. So the general rule of granting the ownership is according to Section 18, subsection 2 of the Patent Act. The patent shall belong to the inventor, but any person may make an application for the patent either alone or jointly with another, according to Section 18, subsection 1 of Patent Act. So generally, the inventor would become the patentee if the inventor made an application according to the law provided. So this is the common understanding. The inventor is the person who pay effort to put in so much effort to make his invention shall actually to being the first person to own an intellectual property right over his invention. So the general rule is clear. The inventor shall have the patent and the inventor shall be the patentee, in other words. So also according to regulation 10 of the patents regulation, even if the inventor does not make an application for the patent, but he could provide a statement justifying his right to the patent and also state the identity of the inventor in his request for grant for a patent. So reading these two sections together, they are actually providing us a picture that the inventor has the right to make an application to have the patent. So they should have the patent in the first place according to the general rule. But there are still several exceptions apply, and the first exception is judicial assignment. Now according to this section 19 of Patent Act, if the essential element of the invention claimed in the patent is unlawfully derived for an invention for which the right the patent belongs to another person, then the court shall make an order for the said patent to be assigned to him. So, for example, the judicial assignment do not grant the patent to me, then I will not have the patent, even though might be the inventor, but the invention is actually unlawfully derived from other person. So in this case, I will not have the patent. Or for example, other persons steal my invention and make an application to have the patent to the invention. I could use this section as well to have the patent to be granted for me. But it only subject to, there is a time limitation. So the court will not entertain the application for the assignment of a patent after 5 years. So there's a time limitation of 5 years in this application for judicial assignment. Now moving on to next, second exception. If there is an employee or person to a commission, so during the his working invention, instead the employee have the patent right over the invention. So in this case, there are actually two circumstances to be discussed. One is the invention made within the scope of an employee, duty, or commissioner works. So means the duty of the employee is to make an invention. So if we read section 21, if the employee made an invention in pursuant to his commissioner work or is his employment duty, the patent will not granted to the employee but the employer. So unless the party could prove they are not employer and employee, they are master and servant relationship. Otherwise, the patent will still granted to the employer. This is because the master and servant relationship is different with the employer and employee relationship. The master does not play the role of employer, and the servant is not the employee. The servant is actually a contractor. According to the case of Transa Chief Sundaram Berhad case, a contractor could not be the employee at the same time. So if a person could prove they is actually a contractor or servant to his master, so they is not employee, so the section could not be applied. So the master and servant relationship will make the inventor to be entitled for the patent, but it must be proven there is no relationship of employer-employee. In this case also, Song Seng Palm Oil Mill, Gamal Sundaram Berhad, and Jang Kim Luang, Yo Kim Luang. Actually, there are three situations that lay down the employee will not have the patent right. So the first one is there is a contract of employment or commissioner work, and then there is a activity is carried out as in the contract of employment or in the execution of the commissioner work. That means the invention or the working of the in the invention is actually the duty of the employee. And then in the contract as well, there is no contract to show the pattern of the invention will go to employee. If there is no such clauses in the contract of employment, then the ownership will, according to the section 20 subsection 1, granted to the employer. To balance the unequal, as you can see, the employee actually puts so much effort to make the invention. So actually the law actually asks the employer to pay for the equitable remuneration according to section 20 subsection 1, and it could not be restricted by the contract that restrict giving of equitable remuneration. So even though the inventor is the employee, would not have the right, would not have the ownership of the patent, but they are still entitled to equitable remuneration. So it's a way to balance the unequal between the effort and the ownership. So what is if the invention made outside of the scope of the employee but using employer facilities? Now, according to section 20, subsection 2 as well, if an employee made an invention but not his duty, but using the employer facilities, according to this section, the invention will be granted to the employer as well. Similar to just now, to balance the unequal, because it's his own effort to make the invention. It's not even the duty to the employee to make such invention, but since the facilities that the employee use is actually belong to employer, so and the law said that the patent should be granted to the employer, so there is a remedy to the inventor as well. The employee shall be entitled to the equitable remuneration, which fixed by the court. So there are several consideration will be taking account by the court for example, the economic value of the invention. So moving on, the next exception is the invention by government employee. Now, according to section 21 of Patent Act, provided the government employee of a government organization or enterprise, unless there is other way around provided in the contract, the invention made by the government employee will not have the right over the patent for his invention. This means is the employee, if a government employee made an invention, the employee of the government will not have the patent right. And now, even though the section 20 subsection 3 prohibit the restriction on the equitable remuneration, but in practice, the government regulation is more restricted in practice. This means in practice, the government employee will not only do not have the right to the patent for his invention and might not have the equitable remuneration according to the government regulation and rules. So once we actually already determine who has the patent right for his invention, now is the time for us to discuss the right of the patent owner by virtue of section 26 subsection 1 of Patent Act 1983. So if you are the patentee, if you are the patent owner, then you have the right to exploit the patented invention, and then the right to assign or transmit the patent, and also the right to conclude the license contract. So what is the what is the right to exploit is actually defined in the section 26, subsection 3. So if the patent is regarding a product, so making, importing, offering for sale, selling, or using the product, and also stocking such product for purpose of offering for sale, selling, or using is exclusive right of exploitation belong to the patent owner. So those who do not have the patent ownership could not make or import or sell the such product without the prior consent of the patent owner. So if the patent is regarding a process, so using the process or doing any act referring to paragraph A is actually prohibited as well. So no matter it's a product or a process, so if the person do not have the patent ownership, would not have the right to exploit the patent. So these are all the right of the patent owner, and we already discussed how to determine the ownership. So thank you.
Assalamualaikum warahmatullahi wabarakatuh, and a very good day to Dr. KHADIJAH. This is ALIAH FARHAH KAMAL, matrix number 264335. And continuing to my part, I will touch on the rights of patent owner to assign any patent rights to others, as well as to form license contract for the patent. According to Section 36(1)(b) of Patent Act 1983, a patent owner has the right to assign or transmit the patent. What is a patent assignment? It is an agreement where one entity, the assigner, transfers all or part of his or her rights, title, and interest in a patent or patent application to another entity, which is the assignee. Assignee will be eligible to receive the original owner's interest and exclusive rights of the patent. Assignee can license and then enforce the patent. Assignee could pursue patent protection and sue irresponsible parties who are making or selling the patented design or invention, although the idea of the product or process does not originate from him or her. In Fukuyama Automation Syndrome Berhad against Shin Engineering Syndrome Berhad and others, the assignee, however, failed to sue the irresponsible parties. In this case, plaintiff contended that defendants had infringed a patent relating to an apparatus for the peeling of thin film material that was granted to him by Fukuyama Netoken through a deed of assignment by producing and selling apparatus which consisted of similar features. In rebuttal, defendants argued that the deed was not an absolute assignment. The assigner only intended to give the plaintiff license and right to manufacture the machinery directly within the territory of Malaysia. The court then settled that plaintiff had no cause of action to bring the claim as the assigner still retained and controlled the ownership of the patent. In general, most assignments transfer all rights, title, and interests of a patent throughout the world. However, in some countries, the assignment might not be legally effective until the assignment has been recorded. Since patents are territorial rights, the exclusive rights are only applicable in the country or region in which a patent has been filed and granted, in accordance with the law of that particular country or region. Hence, assignee cannot enforce the patent rights or claim damages for any infringement that occurred before it has been recorded. Section 39 is a guideline on assignment and transmission of patent application and patents. Next, in Section 36(1)(c), a patent owner also has the right to conclude license contracts. The meaning of license contract is any contract which the owner of a patent, which is the licensor, grants to another person or enterprise, which is the licensee, a license to do any or all of the acts denoted in paragraph 1A and subsection 36(3) of Patent Act 1983. Section 36(3) is regarding exploitation of patent. Licensee may assign the rights to another person or enterprise as mentioned in Section 43(1) of the Patent Act 1983. Within the whole geographical area of Malaysia without limitation as to time and through any application of the invention. However, there is an implication of this. It leads to accumulation of another layer of ownership over the patent. However, according to Section 44(2) of the same Patent Act, licensee cannot give to a third person his agreement to perform in Malaysia in respect of the patent whenever such license contract has prevented the licensee from doing so. This could be derived from the agreement between the licensor and licensee. Similarly, licensor may also grant a further license to a third person in respect of the same patent or for his own use under Section 43(1) of the Act. Nonetheless, if the contract provides that the license is exclusive, the licensor shall not grant a further license to a third person in respect of the same patent by virtue of Section 44(2). Accordingly, the license contract shall be in writing, signed by or on behalf of the contracting parties as stipulated in Section 41(2) of Patent Act 1983. It should be noted that the original patent owner will not change in licensing a patent. Most licenses have a time limit, and thus, at the end of the period, the original owner of the patent will take full control of it once again. In general, licensee pays royalty fees throughout the license period to the patent owner. Hence, if the royalty fees are high and the license period is long, it is believed that a patent assignment may be a better choice for the new owner to generate more profit. To conclude this part, in a license agreement, the patent owner gives another entity, the licensee, permission to use the patented technology while the patent owner retains ownership. Meanwhile, for patent assignment, the original owner transfers the ownership to another entity, the assignee, permanently. With that, thank you.
Greetings to Dr. Khadijah. My name is Lee Gafi with matrix number 270605. Now, I would like to continue our presentations with the topics infringement of patent rights. I will start my presentation with the subtopics acts deemed to be an infringement, followed by the consequences of the infringement, the right to institute court proceedings, the injunction and award of damage, the claims of patents, and followed by the further discussion of direct infringement, 3 essential steps in an infringement proceedings, and lastly, end with imminent infringement. So now, without further ado, I will proceed with my presentation on discussing the first subtopic, the act deemed to be an infringement. The infringement of patent has been described under Section 58 of Patent Act 1983, which is subjected to Section 37, subsection 1, 2, and 3, and Section 38, which is stated that an infringement of patent shall consist of the performance of any act in referring to Section 36 3 of Patent Act by a person other than the owner of the patent and without the agreement of the latter in relation to a product or process falling within the scope of protection of the patents. So now I will talk about the acts that refer to Section 36, subsection 3 of Patent Act, which is about the exploitation of a patent invention. For the purpose of this part, Section 36, subsection 3 of Patent Act had prescribed about the exploitation of a patent invention means any of the following acts in relation to a patent. Before that, we need to understand that the exploitation of a patent invention is one of the exclusive rights of the owner of a patent in relation to a patent, according to Section 36, subsection 1 of the Patent Act. So now, under Section 36, subsection 3A, it stated that when the patent had been granted in respect of a product, the owner of patent shall have the right to exploit the patent by making, importing, offering, selling, using the products and stocking such products for the purpose offering for sales, selling or using. Meanwhile, Section 36, subsection 3, subsection B mentions about when the patent had been granted in respect of a process, the owner of patent shall have the same right in using the process and doing any of the acts referred to the Section 36, subsection 3A in respect of a product obtained directly by means of the process. Generally, the purpose of patenting an invention is because the patent owner intends to recover the expenses that had been incurred in the making of inventions and its development for industrial applications such as sales of products which incorporating the inventions. This is because that the invention is usually involved a considerable expenses for the applicants and the future owner of the patent for the inventions. Hence, the consequences of the infringement of patents might cause damage to the owner of the patents, which includes the losses of profits that the patent owner would have gained without the infringement. Thus, the owner of the patent have the right to take some legal actions, such as a patent litigations, in order to protect their patent inventions against the infringement. Now, I will continue my presentation with the rights to institute court proceedings. According to Section 59 of Patent Act 1983, it prescribed that the owner of the patent shall have the right to institute court proceedings against any person who infringe or is infringed the patents or had performed acts such as are likely to infringe the patents. This means that the owner has the right to sue the infringing parties and to stop him from infringing, as well as to claim for compensation pertaining to such unauthorized use. However, if you observe in the Section 59 subsection 3, you will find that there are limitations regarding to such infringement proceedings, which is the proceedings in subsection 1 and 2 may not be instituted after 5 years from the act of infringement. Thus, it is crucial to institute the infringement proceedings within the time limitations. Otherwise, the owner of the patent his patent has been infringed will not able to claim for remedies in the court. Section 60 of the Patent Act 1983 has expressed the injunction and award of damage that will be granted by the courts to the owner of patents if his patent had been infringed by third party. According to Section 60 of the Patent Act 1983, subsection 1, which stated that if the owner of the patent proves that an infringement has been committed or is being committed, the court shall award damage and shall grant an injunction to prevent further infringement and any other legal remedies. This shows that a grant patent does not enforce automatically. It is up to the owner of the patent to institute infringement proceedings for any infringement of his patent rights. Besides, we can see that the burden of proof of the infringement of patents also falls on the owner of patents, as what is stated under Section 60 of Patent Act 1983. Besides, subsection 2 also stated that if the owner of the patent proves imminent infringement, the court shall also grant an injunction to prevent infringement and any other legal remedies. Now, I will discuss on the claims of patents. The claims of patent means that the scopes of the protection which conferred by a patent. The patent claims act as a notice to the others on what not to do in order to avoid infringement liability to the patents. So basically, the independent claims are the claims that stand on their own and depends on one embodiment or several embodiments of the patents. The embodiments of the patents claims most often appears in the description of the patent application. It is used to introduce the implement of the methods and the process of the invention. After understanding of the meaning of the claims of patents, now we will discuss on the direct infringement of the patents. The direct infringement of the patents is the situation where the patent has been infringed by an authorized third party who puts no effort to avoid the infringement of a patent claims. It is an act of infringement of all elements of that patent claims by a single entity. This means that the direct infringement occurs when a single entity's products or service meets all the limitations of at least one independent claims in your patents. Furthermore, in order to determine if a person is liable in a direct infringement or not, it does not require the party in question to know about the existence of your patents. This is because if all the features of the patents has been copied, hence it has already constituted an infringement. Thus, the only matter to be resolved is whether the claims of the patent is valid or not. In order to success in the patent litigation against the infringement that occurs, we have to take note that there are three essential steps in an infringement proceedings that we need to follow. Firstly, the owner of patent must prove his ownership of a valid patent. This usually can be proved by showing the documents of the ownership at the outset of the patent process. Secondly, the owner of patents proving an act of direct infringement. The act of direct infringement under Section 58 of Patent Act 1983 has to read together with Section 36, subsection 3, which we have mentioned earlier before, is the infringing party must have engaged in one of the 5 prescribed activities that makes one guilty of the infringement. The 5 acts are prohibited under this provision when it is performed without the consent of the owner of the patents. The 5 acts includes the making, the importing, the selling, using the patent inventions, or offering a patent invention for sales. Lastly, the final step of an infringement proceeding is the owner of patent need to prove that the infringement product or process incorporates all the distinguished features of at least one independent claim it is not enough for the patent owner to broadly state that his patent had been infringed, but the patent owner had to be more specific when instituting the infringement proceeding in the courts. The defendant's products or process had to be compared to the protected patent claim to determine whether it infringed the patents or not. In an independent claim for direct infringement, every step in the said independent claim had to be fulfilled to prove that there is direct infringement. Lastly, we have come to the last slide of my presentations. I will discuss on the imminent infringement. Imminent infringement refers to a situation where actual infringement has not yet occurred but is threatened. This had been expressed in Section 59, subsection 2 of Patent Act 1983, which is stated that the owner of a patent possesses the same rights against any person who performs acts that make it likely that the infringement will occur. However, it should be noted that such infringement proceedings was same like the normal infringement proceedings. It cannot be instituted after 5 years from the act of infringement as prescribed under Section 59, subsection 3 of Patent Act 1983. Is similar to direct infringement. Section 60, subsection 2 of the Patent Act provides that the patent owner is entitled to an injunction if the patent owner successfully proves an imminent infringement. The court may grant an injunction to prevent the infringement and may provide any other legal remedies it deemed necessary. In practice, the plaintiff also can claim for the payments of costs and an order to court to compel the defendant to pay for any damage that caused by his act on attempt the infringement. By that, I will end my presentation. Thank you.
In conclusion, although there are benefits provided by a patent, it is not easy to have an invention patented. A patentable invention shall be new, involving inventive steps, as well as is industrially applicable. Only when the three requirements are fulfilled conjunctively, a patent is legally granted. The PA starts its protection over an invention when it is patented under the Act itself. The patentee may avoid other people gaining benefit from his invention. Furthermore, he is at free to assign any right of such patent to other person or choose to form license contract for the patent at his will. Every invention is vital to be appreciated and protected, and it does not come from no way but the time and the energy the inventor has vested on it. Therefore, the PA is also important as it is the key to protect them legally. Patents stand for you when everything else is lost. That's all for our presentation today. Thank you for attention.